We're live.
The Honorable Court of Appeals for the 7th District of Texas is now in session.
Thank you. We welcome you to the October 7th, 2020 morning settings of the 7th Court of Appeals. You are the second argument we have this morning. The first one went well generally, and we look forward to the same happening on this one as well. Both of you have appeared before us, so you know how we are. I think maybe your first time you appear before our newest Justice Doss. So you'll have that opportunity to experience him. But I will dispense with what I normally talk about at the beginning and just go on and call the docket. I will not ask for an estimate of your time either, because you know what your time periods are. So with that, we will go on and call 07-19-00424-CV in the matter of IA, a child. Ms. McMillan, are you ready?
Yes, Your Honor.
Okay. Mr. Ford for the state, are you ready?
Ready, Your Honor.
Okay. And I do want to thank you for appearing this way with Zoom. We all are learning a lot about this, and I'm sure all of you have done this many times, and you're becoming much more expert than I am. And I want to thank Ms. Silverman for guiding us through all this as well. So with that said, Ms. McMillan, you have the floor.
Mr. Chief Justice, and may it please the court, my name is Lorna McMillan, and I'm here on behalf of the appellant. And because he's a juvenile, I won't be referring to him by name, just by appellant or my client, but he is a very real 16-year-old boy who has been held in detention for over a year, 350 miles away from his family in the middle of a pandemic. But this case isn't just about my client. This case is about every child who has had or will have encounters with the Texas juvenile justice system and who should be afforded clear, fair, and constitutional due process of law. Your Honors, without proper detention procedures and reasonable timeframes for bringing cases to adjudication, juvenile centers run the risk of becoming plea factories, and children within those centers run the risk of becoming victims of the system. With that in mind, this court should reverse the decision of the lower court and order the immediate release of my client pending trial for two reasons. First, my client is being detained by an order that lacks jurisdiction under chapters 51 and 201 of the Texas Family Code. Second, my client has been unconstitutionally detained for more than 1 year with no trial date in the foreseeable future and with no possibility of release, which therefore has violated his due process. Before I turn to my first point, Your Honor. Oh, yes,
you mentioned something just now that struck a chord in my memory with regard to something I read, and I think it was in your brief, speedy trial. For some reason, I seem to remember that you mentioned that there may not be a speedy trial right with regard to juveniles. Is that correct?
From the case literature that I've reviewed, in terms of when I was trying to see if a habeas writ was a proper avenue of relief, it did show that there isn't a lot of case law developed here and that juveniles don't have a right to speedy trial. But we think that mandamus is a relief because, or not mandamus, habeas can be a possible relief because there's no motion I can file to make his hearing occur sooner that I can see from the case law. Juvenile law.
I'm curious, if you were to file a habeas, what would you ask for if you don't have a right to a speedy trial?
Well, Your Honor, this is an appeal from a habeas denial. And what we were asking then in that appeal is that we felt that we were entitled to have hearings in front of an elected official, the district court judge who was appointed to the juvenile court, which is
I was talking about I understand what you're saying, but I was talking about the actual delinquency hearing with regard to a juvenile. How would you raise that via habeas?
We raised it via habeas, just stating that there are timeframes within the family code that state when petitions should be filed when a child is in detention and how soon that adjudication hearing must happen. And because it didn't happen.
Isn't section 53.05 of the family code essentially the speedy trial provision for juvenile cases? It sets out a 10-day time frame. The petition is to be filed and puts the onus on the court, not the juvenile, to have the hearing.
Oh, exactly, Your Honor. I think that's why there is no case law directly discussing a right to a speedy trial via normal criminal procedures, but that statute is there. And so the question becomes, when that hearing does not happen within 10 working days, does not happen within what we're now looking at is 15 months of a hearing not being held, what remedy is there to ask the court to set this for an adjudication hearing and release my client from detention?
Well, have you in fact requested an adjudication hearing?
Yes, Your Honor. So the record does show in the state's brief and then also in the amended petitions that the issue was not raised before this was filed, before a habeas motion was filed. I was unaware of that timeframe statute, and we were about 30 days outside that time frame. But after that point, we have asked multiple times on the record in the underlying juvenile case for this to be set for hearing. The pushback to that was that the state did not know if they were going to certify him as a juvenile. I received a statement on the record that they are not going to certify him as an adult, not a juvenile, but they're not going to certify him as an adult. And so now, I don't know what the holdup is, Your Honors, apart from COVID restrictions. This child is still sitting there.
Well, of course, I guess some of what you just told us is not in the record, and we can't take judicial notice of the underlying juvenile proceeding because that action is not properly before us.
Yes, Your Honor. But regardless of whether it was raised prior, I think it's still important for this court to give defense attorneys and juveniles a tool to know what we need to do when cases are not set for adjudication, and even dicta on this matter would really help determine or perhaps hold certain juvenile courts' feet to the fire to say we cannot forget about children and leave them in a juvenile system where they do not have a right to bail, where they are only detained based on a 5-factor finding. If any one of those factors is found, then they can be detained at this point in practice indefinitely if the 10-day working time period statute doesn't apply, if it's just directory.
Well, and certainly within the set out in the family code, the Lubbock County Magistrate has continued to find 2 of the 5 grounds to hold this child, and the underlying orders that we have in the record support that suitable supervision, care, and protection is not being provided by a parent, guardian, custodian, or other person, and then also that the child may be a danger to himself or others if released, and that would be based on the underlying offense of robbery and murder.
Yes, Your Honor, and I know we give deference to the court's facts, and so I won't challenge that the court did make those findings, but there's also a way that those findings can be backdoors, if you will, to punishing a child pre-adjudication.
Because the U.S. Supreme Court case, when they addressed the due process rights of the juvenile, and that does apply in these proceedings, isn't there some support for the fact that there is a decision made in the detention hearing every 10 working days with regard to holding the child?
Yes, Your Honor. So you're referring to the case Shaw versus Martin, which I derive most of my authority in the brief. They found that the way that the statute was written was not a pre-adjudication punishment because the maximum time that a juvenile could be held I believe was 17 or 23 days, but there were consistent limited time periods to bringing that child to an adjudication hearing after he had been detained. The problem with our 5-factor system, Your Honor, though, is that it allows judges to have a method to punish children for the nature of the offense. And the reason I say this is because at this point, if any child is accused of a serious offense, it means that the nature of the crime can keep them in court, or it can keep them in confinement, and it can keep them in confinement until the case is set. And so, and looking at lack of adequate parental supervision, a lot of times the comment is that, well, this crime happened while the parent was supposed to be watching their child. And I would argue, Your Honors, that in every single case where a child is accused of a serious crime, they will almost always be detained because that crime will have happened while a parent was supposed to be watching them. And that crime that they are accused of, but for which they are presumed innocent, because they're accused of a serious crime, they're going to be held in detention. And I'm not disputing that those kids are going to be held in detention for those factors. If that time frame did apply and those kids were only in there for a limited time until we could get them to either to have a plea or to have a trial, either be found not guilty and be released to their families, or be found guilty quickly and get them into the youth commission or on probation, so that we can advance the purposes of the juvenile code, which under 51.01 of the family code is that we are trying to not separate children from their families unless we have to, if there's a danger, but then to provide rehabilitation for those kids, to ensure that they, the language escapes me, Your Honors, but it's to afford them constitutional due process and fair process of law, while also making sure that we balance our interests between crime and children. We obviously want to be tough on crime, and we don't want this to happen, but the family code is so differential to the treatment of children and the best interest of children when it comes to custody cases. But as soon as a child is accused of a crime, that goes out the window. And I feel like we are presuming these children guilty.
And counsel, I understand what your argument is, but with regard to the sufficiency of the factors in the family code, or whether the evidence supports those factors here, those weren't arguments that you made in your brief, were they?
Not as to the sufficiency of the evidence, but it goes toward when using those factors without a time frame to set adjudication becomes this indefinite languishing detention period that transforms into an unconstitutional detention because it's so long and this child does not have, he's going to be detained. There's no way you're going to get around those factors. And so because of that, you have to abide by those timeframes, those limited timeframes. I understand why an adult would be in detention for a year and a half, 2 years awaiting trial, but to keep a child in detention for a year and a half, 2 years away from family, awaiting trial or their final adjudication hearing seems to go against this hybrid value system that we have in the Juvenile Justice Code. And Your Honors, I believe more important than this due process issue and these time period restrictions that need to be clarified, it also is important that we clarify what Judge McNamara's role is on this court. It's Family Code 51.01 subsection 6 that states that one of the goals of the Family Code is to provide a simple judicial procedure through which the provisions of this title are executed and enforced, and in which the parties are assured a fair hearing and their constitutional and other legal rights enforced. These legal rights are not being enforced if the state continues to argue that Judge McNamara is.
Okay, we've got a problem. There you go. Okay, you just froze for a second. Go on. I think you're.
Oh, I apologize.
We didn't hear the last part of your statement. Can you repeat your statement?
Yes, Your Honor. children are not going to be afforded the constitutional protections that they deserve under the Texas Constitution if Judge McNamara is acting as a magistrate who does not, and this court finds that she does not have to give warnings or notices that children are entitled to a hearing in front of the district court judge, who is the juvenile court judge for these matters. The main issue, Your Honors, is that Judge McNamara is an associate judge. She was appointed as an associate judge for juvenile matters in a January 31st, 2012 order appointing her as an associate judge for specifically juvenile matters. That's volume 4 of the record, page 98. Additionally, there is a March 1st, 2012 order of referral, which referred cases to Judge McNamara as an associate judge for juvenile matters under the 201.306 referral statute of the Family Code, in which she was referred all proceedings over which a juvenile court has exclusive original jurisdiction under Title III.
Can a magistrate hear juvenile matters?
Your Honor, a magistrate can hear juvenile matters if they are assigned, referred those under the government
Was she
code.
designated a magistrate to hear juvenile matters too?
She was designated a magistrate. The order designating her a magistrate did not specifically mention juvenile matters. That's the January 30th, 2012 magistrate reappointment. But there was a June 21st, 1999 order that did appoint her as a magistrate. Well, it didn't appoint her as a magistrate. It gave the omnibus referral order for juvenile matters. However, that occurred in 1999. There was a new order of referral issued in 2012. And the date of that new order referring cases to her as an associate judge for juvenile matters is significant because the Family Code was heavily revamped in House Bill 79 in 2011. And in that House bill, you had a lot of provisions for what a referee does or what an associate judge does in terms of how long they may detain someone, how they must refer detention orders to the governing judge, and he must adopt those orders. If a detention order is not adopted within a specific time frame, that detention order loses jurisdiction after 72 hours under the Family Code, and I believe 48 or 201 of the Family Code, and then within 48 hours in Chapter 54 of the Family Code. And so it seemed that the legislature wanted to give specific time limits as to detention orders that were ordered by associate judges, referees, and it does not specifically say magistrate in either of those sections regarding detention orders.
Well,
But
certainly she has signed the detention orders in this case as the Lubbock County magistrate judge. And
Yes.
in Chapter M of the Government Code sets out the authority of the Lubbock County magistrate, and the powers and duties under that statute specifically refers the juvenile law.
It does refer to the juvenile law judge, yes, but it states that they may take a juvenile plea. The specific language of, I think it's 54.874, doesn't specifically state that they can preside over detention hearings. And I think that's because juvenile hearings are a much different process than your typical criminal law proceeding. A plea hearing for juveniles will be much the same, but a detention hearing is different. And those detention orders need to be sent to the judge of the juvenile court. And the judge of the juvenile court is Judge Reyes. He needs to be sent those orders. Additionally, not just those detention orders, Your Honor, if Judge McNamara is a magistrate and does not have to give warnings stating that a juvenile is entitled to a hearing in front of the district court judge, that creates a lot of complications, especially in our statutory construction. The referee statutes and the associate judge statutes specifically state you're supposed to warn a juvenile that you are entitled to a hearing in front of a district court judge. Why? Because that judge is an elected official. A magistrate judge is not an elected official, they are appointed. It would
Is there
follow
anything
that.
under the magistrate statute which says that the magistrate is supposed to give those type of warnings?
No, Your Honor, there's not. I couldn't find any, but I believe that a magistrate should be treated as a referee under the Family Code, that was the intention of the legislature.
Well, nothing, you did not mention any of the orders that you mentioned earlier. None of those orders appoint Judge McNamara as a referee. And there are very distinct and different qualifications or less qualifications for a referee than there is for an associate judge or a criminal magistrate.
Correct, Your Honor, but the requirements for conducting detention hearings or any hearing without the district judge for associate judges under Chapter 201 and also for referees under Section 5410, they're the same. They have to follow the same procedure for detention hearings, including giving that juvenile a right to object to a hearing in front of the district court judge. For associate judges, you would be informed of your right to a de novo hearing, which was not done in this case. In a referee status, you would object to a hearing in front of the referee, and within 24 hours, you would have a hearing in front of the district judge. Right now, the power to be heard in front of the district judge has been eviscerated by this magistrate status, unless this court also holds that you can object to a magistrate and have a hearing in front of the district court judge.
Isn't that the rub here? The statute, the Lubbock County Magistrate statute, does not provide that a litigant can object to the Lubbock County Magistrate under the authority and powers and duties that are prescribed by statute to the Lubbock County Magistrate.
Yes, Your Honor, that's correct. And I see my time is almost up. May I answer your question and conclude?
Sure.
Thank you, Your Honors. There is no portion in the statute that states that you can object to a magistrate judge, except for insofar as that a trial, you can object to a trial before a magistrate. But I will state that the referral order states that that a magistrate can only have jurisdiction over those cases which a juvenile court has original jurisdiction over. And that jurisdictional statute within the Family Code is 51.04. And nowhere in that statute are magistrate judges given any sort of authority to preside over a detention hearing as if they were the juvenile court judge themselves. Everything else in that statute seems to show that there is a district court judge or a juvenile court judge who presides over everything. And then whoever is appointed to serve underneath him or to help him has to send those to the district court judge, and that juveniles are entitled to be heard in front of that elected official. For those reasons, Your Honor, we ask that this court reverse the decision of the trial court and order my client released from detention pending trial.
Thank you. Mr. Ford?
May it please the court?
Counsel.
Your Honors, appellant's first issue addresses whether Judge McNamara was required to recuse herself from any further detention hearings in this case following the defendant's objection to having Judge McNamara hearing further detention hearings. Resolution of this issue depends on whether Judge McNamara qualifies as a referee for purposes of Section 51.04G and 54.01L of the Family Code. The plain language.
You say a quick question. Recuse.
Yes, Your Honor.
Was there an actual motion to recuse filed?
There was a, I don't remember the exact language, the title of it, but it was basically a motion to recuse Judge McNamara and to have Judge Reyes hear further detention hearings. Yes, Your Honor. And
Judge McNamara overruled a motion to recuse?
Yes, Your Honor. It's in the record that Judge McNamara, for both of the detention hearings for which we have a transcript of, Judge McNamara did overrule the motions.
Can a district judge overrule a motion to recuse himself, or does it have to be referred to?
I believe the record evidence is going to show that it was not a motion to recuse, but it was an objection to Judge McNamara serving. It was treating her like she was an associate judge or a referee under the Family Code. And you can object to, under the provisions of under 201, for an associate judge hearing or a referee hearing the detention hearing.
But that's what I wanted to clarify. It was actually a motion to recuse, which is treated in one way generally, but okay. So it wasn't a motion to recuse, as an objection. And
Right.
she overruled the objection, basically.
Yeah.
Okay.
Yes, Your Honor, it was titled as an objection.
Well, Mr.
The-
Ford, since the referee can only be appointed if the juvenile court judge is unavailable, is there any record evidence that the juvenile court was unavailable?
No, Your Honor, I'm not aware of any evidence that Judge Reyes was unavailable.
And if not, then Judge McNamara would not be hearing the hearing as a referee.
Yeah, yes, Your Honor, that's correct. There's no evidence that Judge McNamara was hearing the cases as a referee. She was hearing the case as a Lubbock County magistrate. She was appointed. She was appointed for three different things. It showed the respondents exhibits 1 through 5. She's been appointed as a criminal associate judge, a Lubbock County magistrate, and an associate judge for juvenile matters.
Okay. Under what circumstance would Judge McNamara serve as the associate judge for juvenile matters?
Yeah, Your Honor, both the Lubbock County magistrate role and the associate judge for juvenile matters role have very overlapping responsibilities. In fact, the powers of both are almost that exact same there, with the possible exception of contempt authority. I couldn't actually find anything different other than that magistrate rule on a pretrial motion, whereas there's nothing saying that associate judge can rule on pretrial motion. So to answer your question, I couldn't find anything that would require Judge McNamara to wear a hat of an associate judge for juvenile matters as opposed to a magistrate.
Let me ask a follow-up question related to that. Are those powers that are deferred to the magistrate or to the associate judge, are those created in statute, or are those created by standing referral order?
The powers for an associate judge and for Lubbock County magistrate, for that matter, are created by statute. The positions are created by statute. Associate judge for juvenile matter position is created in Chapter 201 of the Family Code, and the Lubbock County magistrate is in Chapter 54, Subchapter M.
If the district court exceeds that statutory authority of what can be delegated to the magistrate or the associate judge, does that divest the associate judge of jurisdiction to handle those other matters?
If it goes beyond the authority of either the statute or the order, it'd probably have to be a writ of habeas corpus that'd be filed saying that the magistrate or the associate judge doesn't have the authority to rule in that matter, to take the particular action being challenged.
So basically, the answer is yes. If the referring judge cannot refer it, then the magistrate or associate judge has no jurisdiction.
Yeah. Yes, Your Honor. It has no jurisdiction over the particular thing being challenged. Yes, sir.
Okay. When we're talking, if I'm sorry, Judge Parker, go on.
No. The Government Code Section 54.878 parentheses 10 lists, that's part of the duties or the powers of the Lubbock County magistrate. Is it your contention that a detention hearing is a pretrial motion? Did I read that in your briefing?
Yes, Your Honor, that is correct. That a magistrate judge would have the authority to rule on a detention request as a pretrial motion.
Does an associate judge?
An associate judge, I'm not entirely sure if a associate judge has that power or not. What I can say is that associate judge, unlike a magistrate, has to give the warnings that opposing counsel has discussed.
Well, that leads me to a question I had. You said earlier that there's a lot of overlap, and I may be taking too much liberty, but you made me think that they're basically the same. The powers are basically the same between associate judge and magistrate. And then I thought, well, except for one instance. wearing one hat, you have to give admonishments and warnings. Wearing the other hat, you don't. Is that generally true?
Yes, Your Honor, that's generally true. I said with very limited exception, pretrial motion and contempt authority are the only two differences I could find. But with absent that, the two roles are very similar, have overlapping responsibilities in both.
So
the Lubbock County magistrate would not be able to hear a final contested adjudication. But under the associate judge juvenile law matters statute, the associate judge could hear, and then there would be a de novo hearing before the referring court. Wouldn't that be the difference between, or at least some of the differences between the magistrate position and the associate judge for juvenile matters?
Once you get past the pretrial issues and get to trial, yes, Your Honor, that is absolutely a difference between the two there. 54.8778 discusses powers in a pretrial matter. Once you get to a adjudication hearing, disposition hearing to modify, that would be something that the associate judge could handle, whereas the Lubbock County magistrate cannot.
So how does the defense bar know when Judge McNamara is in her role as Lubbock County magistrate versus her role as associate judge for juvenile matters?
The default is that Judge McNamara acts as a Lubbock County magistrate. Her office is called the Office of Lubbock County Magistrate. When you go into the courthouse there and look up at her office there, it specifically says Magistrate Judge McNamara.
Can she act as an associate judge when she's in her magistrate office?
Yes,
or is the title of her office when you walk in, since it says magistrate, preclude her from being an associate judge?
No, Your Honor, there's nothing that precludes her from acting as a magistrate. What I've heard anecdotally is that she will, if she has to act in a different role from being a magistrate, that she'll specifically say that she's acting in her role as the example given here as an associate judge for juvenile matters. But if she doesn't specifically say that, like for example in the juvenile detention hearing, she did not specifically say that she was acting as a magistrate. So the default role is that she's acting as a magistrate unless she specifically says otherwise.
So you have the one person, dual roles. Under one role, they have to give certain admonishments. Under the other role, they don't have to give certain admonishments, but those admonishments affect the same proceeding.
Yes, sir.
Does that lend to abuse? Where the person said, well, I don't want to have to give them admonishments. So today, I'm going to be a magistrate. Tomorrow, I may be an associate because I like that person. I will give them admonishments. Why shouldn't they be treated the same?
Because the legislature did not intend for them to be treated the same. The magistrate role preceded the associate judge for juvenile matters. Judge McNamara, or her predecessor, was appointed as a Lubbock County magistrate. Respondents Exhibit 3 shows that order signed June 21.
Other than the statute that you just mentioned, is there a rationale, a reason, a policy behind not requiring a magistrate to give the admonishments, but requiring the associate judge? Is there some rationale aside from the statute?
Aside from the statute, I couldn't find it, Your Honor.
What is the reason for giving those admonishments to begin with, do you think?
At least in the associate judge role, I would say that the legislature, I would say that the legislature intended for those admonishments to be given because of the nature of their role, especially since oftentimes we're going to be talking about proceeding to trial there, as opposed to merely a pretrial issue there. If you're talking about trial there, then certainly there would absolutely be constitutional authority and right to be tried in front of an elected judge as opposed to an appointed judge. So that would be the primary reason that I could see for why those admonishments would be required prior to trial for an associate judge for juvenile matters, but would not be required for the Lubbock County magistrate in a pretrial setting.
So there's some due process issues involved, potentially?
There'd be the due process issues involved if we're talking about proceeding to trial. Yes, sir.
Okay. And you don't think those due process issues would be involved with regard to pretrial leading eventually to trial? Because I guess the magistrate could do all what you're saying is do all the pretrial, then all of a sudden say, okay, I'm going to switch hats and become the associate judge so I can do the final adjudication. But before I do that, I got to give you these warnings.
Yes, Your Honor. Those warnings would be required prior to trial, and then the defendant would be able to object to having the magistrate or the associate judge hear the adjudication disposition.
And if that one party decided to be associate judge throughout, they'd have to give those admonishments from the get-go?
If, for example, some other county where there is not a Lubbock County magistrate and is
No, I'm
merely
talking
acting.
about our situation.
In our situation, if for some reason I can't fathom, Judge McNamara were acting as an associate judge in a pretrial setting as opposed to acting as a Lubbock County magistrate, then those admonishments would be required pursuant to Chapter 201.
From the get-go?
From the get-go, yes, sir.
Okay. So the judge, at least in our situation, can choose when to give the admonishments or not by just saying, oh, today I'm going to wear a purple robe, tomorrow I'm going to wear a black robe, or I'm going to wear a red hat, tomorrow I'll wear a gray hat, as arbitrarily as that.
Yeah, I don't believe that there's anything arbitrary in the judge's role, because her default role is that she's acting as Lubbock County magistrate. That was the referral order in June 21, 1999. Referring all juvenile proceedings to the Lubbock County magistrate, and the orders that opposing counsel referred to during her argument, she was reappointed as the Lubbock County magistrate in 2012, whereas she was appointed for the first time as an associate judge. So her default has always been, for the entire time that I've been in office, I'm aware of, that she is a Lubbock County magistrate.
But she can choose which one to do.
She has the authority to choose which one to do, but the default would be that she's magistrate unless for some reason she has to act as an associate judge for juvenile matters or as a criminal associate judge.
So if I understand what you're saying, the standing order gets to determine what the default is, not the statute that says juvenile matters are handled under the family code? Why would she not be more appropriate as an associate judge under those circumstances? Because that's what the family code says.
Because that's what her office is. When she was first appointed in the job, she was appointed as the Lubbock County magistrate. She wasn't appointed as an associate judge for juvenile matters. It wasn't until years later that she actually became an associate judge for juvenile matters. But her office is the office of Lubbock County magistrate. That is the default role that she acts in, unless she expressly says otherwise. So, such as, for example, if she's.
Well, is there any order that says you've got a default role that's automatic unless you say otherwise, or is that her choice?
I believe that would be based on her appointment as a Lubbock County magistrate.
That's what I'm asking. Is there any order in appointing, any appointment order saying your default role is magistrate, or is it left to her choice whether to act as associate judge or magistrate in a proceeding?
There's nothing in the orders that expressly states as such. That would just be based on what she has been, what she was hired for.
Okay, thank you.
Yeah, Your Honors, I will move to the second argument. I see I only have 4 minutes. I'll address the appellant's second argument, which discusses the due process issue of whether the court violated Section 5305 of the Family Code by failing to set a time for the adjudication hearing to be held within 10 working days. As opposing counsel noted, multiple courts have repeatedly said that the 10-day requirement of 53.05B is directory rather than mandatory. There's nothing expressly.
The statute says shall, correct?
Yes, Your Honor.
And I understand I love it when people take mandatory word and say, they really don't mean what they mean. A table is not a table, even though it's a table. So they said it's directory, and you're saying, if I remember right, you were talking about that with regard to directory as it relates to dismissing the proceeding. It's a directory, so you can't really dismiss. Is that what those cases are talking about?
The cases talk about both the mandatory and jurisdictional requirement there, that a violation of 53.005 does not lead to this dismissal.
Okay, dismissal because you don't lose your jurisdiction, basically.
Yes, Your Honor. That would be the only remedy.
Okay, is that related? Is the directory language related to not losing your jurisdiction and being able to dismiss? Or does it have other meaning with regard to, hey, you got to eventually try these matters or hear these matters? In other words, you say shall, what's the remedy? Are you saying there's no remedy? You can take a shall and delay forever?
I'm certainly not saying that that delay can be done forever. Justice Dawson noted during opposing counsel's argument that sufficiency has not been raised on appeal here, but just because sufficiency has not been raised here, it was raised at the lower court level there, because there has to be every 10 working days, there has to be another continuing detention hearing to determine whether the factors are still present there. So there isn't really any question that that delay can go on indefinitely there. It's just a matter of what is the remedy for a violation of 53.05B and the 10-day requirement there. And the answer is there is no remedy for a violation of that 10 working day rule. And the reason for that is because the legislature intended the statute to be directory in order to further the purpose of Title III, which is protecting the rights of juveniles and ensuring public safety and welfare. Given the nature of the offenses here, appellant has been charged with the offenses of murder and aggravated robbery there. Given the nature of the offenses and in order to protect the interests of both society and appellant, his detention serves a legitimate regulatory purpose, which is compatible with the fundamental fairness demanded by the Due Process Clause in juvenile proceedings.
Does a juvenile have a right to presumption of innocence?
Yes, Your Honor, absolutely.
Okay,
Well,
so
is it a violation of a defendant's due process rights if the defendant were an adult incarcerated pending trial without bail based solely on the crime that the defendant was alleged to have committed?
Your Honor, I'm not sure whether it says Article says 1715 of the Code of Criminal Procedure governs adult confinement there, and it's a multi-factored approach, one of which, of course, is the interests of society there. So you would have to consider a multifaceted approach, but certainly the protection of society is a valid consideration in adult confinement.
Well, at what point in time does holding this child without an adjudication hearing become a due process violation?
Your Honor, I don't have an answer for that. There's nothing, no case law I've been able to find giving a set time period for when pretrial incarceration for juvenile becomes a due process violation.
Have you in effect had a de facto adjudication hearing here every time you had that 10-day hearing and the court says you're a threat to society because you're a murderer?
No, Your Honor. Certainly there has been no finding of guilt here. This is the 10-day requirement is only for purposes of continued pretrial detention.
But in effect, they're saying you've been charged with murder, and boy, that's bad. And so we're going to keep you locked up for some more. Isn't that kind of a quasi adjudication if it continues forever? Which you said it could.
Well, Your Honor, it's certainly no different than an adult who is incarcerated for a year or two. There's no finding of guilt, even if the adult continues to be confined for a lengthy period of time. Likewise, there has been no adjudication here just because the appellant has been incarcerated for over a year.
So the adult would have the benefit of the Speedy Trial Act. which in essence is what the Family Code section 53.05 embodies. It gives a short or a 10-day time limit, and understanding that that limit can be longer, for example, for a psychological evaluation, if there's going to be a certification as an adult. And there are cases, and I believe you cite them in your brief, that deals with those situations. I couldn't find a case that dealt with the due process argument. If the child's not certified, how long is too long to hold without having the adjudication hearing? Because under subsection A of the statute, under 53.05, the burden is on the judge to set the hearing. And certainly the judge in this case would have had notice when the habeas corpus proceeding was going on. And at that time, the child had been held for 86 days.
Mr. Ford, we're going to let you answer that question. I know the time's expired, and unless the judges have other questions, we'll let you answer this one, and then we'll flip on over to Ms. McMillan and a rebuttal.
Okay, yes, sir. Justice Parker, there's no specific time period before which pretrial incarceration becomes oppressive there. But what I can say is that pretrial proceedings are about to happen in this case. So it's not like that appellant is just languishing without anything happening in his case.
That's only been the case for the last year.
Excuse me, Your Honor?
That's only been the case for the last year that nothing has occurred.
Nothing has occurred that's in the record. That doesn't mean that pretrial hearings haven't been happening or will be happening in the future here pretty soon, is my understanding outside the record.
Thank you, Mr. Ford.
Thank you.
Any other questions of Mr. Ford of the state? And Mr. Ford, want to say that you're a good sport for allowing us to continue to ask questions. You've been in front of this court many times, and you know we do that, and we appreciate your calmness and answering our questions in that regard.
Your Honor, thank you.
And Ms. McMillan, I'm going to turn it on over to you.
Yes, Your Honors. 2 points on rebuttal. And first, outside the record, I have had no notification at all that pretrial hearings will be proceeding soon. But first, Justice Parker, you asked the state when the defense bar is supposed to know when Judge McNamara is acting as a magistrate and when she's acting as an associate judge. And the state responded that the default is that she is acting as a magistrate. But Your Honors, default is not the standard for constitutional due process. The state's argument is essentially, we do this because this is the way we've always done it. But the most recent order of the Board of Judges from Lubbock County specifically appoints and refers cases to Judge McNamara as an associate judge for juvenile matters. This is what the Board of Judges authorized her to do. And while under her appointment as an associate judge or even a magistrate judge, those orders can limit her powers, they cannot expand them. So even her order of referral under the magistrate status does not expand her powers under 54.878 of the government code to include the power to detain juveniles. It is not enumerated there.
Well, the Board of Judges has a responsibility of reappointing the associate judges, I believe it's every 4 years, as a matter of course. There's nothing in the order itself that says, for example, that the order would expire.
Correct, Your Honor, and I don't believe it did expire, but I believe it was substituted, although it doesn't say it in name, by the very specific order appointing her as a judge for juvenile matters and then referring those juvenile matters to her after the statute was amended and House Bill 79 was passed in 2011. Right around
both of those statutes work together, though. There would be some responsibilities and powers as the associate judge for juvenile matters, hearing a final adjudication, for example, that Judge McNamara would not have as the Lubbock County magistrate. And so those orders could work together, couldn't they?
They could potentially work together if jurisdiction for a magistrate to proceed outside of Chapter 4 of the Juvenile Code was authorized, but they're bound by those jurisdictional limits of 54.01, and a magistrate can only proceed unless that juvenile court judge is otherwise unavailable. As the state stated, he wasn't otherwise unavailable.
No, that's for a referee, I believe.
Oh, no, Your Honor, the referee was under subsection, I believe, G, but the magistrate is under subsection G. Referee is the one just right after that. The referee is appointed, and the referee can proceed over all matters of the course so long as those cases are referred to them under that appointment status. Your Honor, Second Chief Justice Quinn, my second point, you asked if this statute says shall, and it does. And yes, there are some cases, none controlling at this point for this jurisdiction, of whether that's mandatory or directory in nature. And yes, the burden is on the court to hold that hearing. There is some instructive case law from Texarkana in the matter of SD, which was cited in my brief, that the delay was only justified where the trial court could not conduct a diagnostic study that was mandatory. So basically that adult certification, which you referenced, Justice Parker, when certification as an adult isn't an issue, when the investigation has been closed, the burden is then on the state and the judge to say, all right, we have to have this trial. We have to adjudicate, you're out of excuses. And I guess maybe mandamus relief is the juveniles maybe avenue after that. I'm not sure.
Let me ask you a question along those lines. Suppose Mr. Ford is correct and the state does decide to have an adjudication hearing on month 16 after your client's been held. Does that moot your second issue?
No, Your Honor, it doesn't, because he's still been violated. He's had constitutional due process issues this whole entire time. And Shaw versus Martin,
what would the remedy be if there's a finding at that adjudication hearing that your client should continue to be held?
I think you would look to whether the defendant was irreparably harmed by how long it took that case to get to trial, and the irreparable harm and fundamental harm that he suffered while he was in detention, not being treated as a juvenile is supposed to be treated, not being afforded constitutional due process while evidence sits around and we wait for fact finders to come and testify at trial. This could go on indefinitely, Your Honors.
That sounds a little bit like considerations regarding or underlying speedy trial. The loss of evidence and sitting in jail and all that.
And I believe that's probably the analysis that we should apply in this context to juveniles. What are the standards of a violation of due process for violating the speedy trial right? Apply those to these time frame statutes, and I think that we would have a good workable framework for when these cases are supposed to be brought to trial. Because, Your Honors, we can't just leave these children in detention, essentially adjudicate them because of the nature of the offense, in which case my client is only being charged of robbery and murder under the law of parties. He was not near the offense when it happened, and that's all on the record. And so we do need a way for this to be brought to trial. Otherwise, we deprive children of their constitutional rights and treat them like second-class citizens and like they're not entitled to the same constitutional protections as adults. Thank you, Your Honors.
Any questions? Ms. McMillan, you've argued in front of our court numerous times too, and you too have been the recipient of numerous questions too, and we thank you for answering them straightforward as well. Thank both of the counsel for participating with us in this proceeding via Zoom, and God willing, things will change and we will be able to sit in the same room together soon. But with that said, the case is submitted and you are excused to go, and we will be in recess until this afternoon, 1:30, if I'm not mistaken.